afternoon, everyone. Thank you for your interest in joining us for this. Is the last Hantel Tech seminar of the year. So we're really excited to be able to welcome Erik Milch and also John Mills, who just arrived this morning from Virginia. So his first stop in California. So we're excited to hear what they're going to have to share about FTO and competitive intelligence, as well as how to use the competitive IP to advantage. These are very relevant for our community in startups and medical devices, and both of them are from representing Cooley. So I think, and also both have had backgrounds in engineering as well, which also helps to make strengthen their understanding for clients and also our clients as well. Without much further ado, I will just let John go ahead and take, and also Erik, so go ahead and take the floor.
Thanks, Julianne. Thank you for having us. Really happy to be here. And we're going to sort of hold questions until the end, but just write them down, keep them in mind as we go through this. Real quick about Cooley. Cooley is a national law firm. We have offices much closer than our Reston, Virginia office, so we're here in Palo Alto, San Francisco, 9 other offices in the U.S. plus in Shanghai. So we have 700 attorneys. A significant practice of ours is the life sciences practice. We have over 650 life sciences clients, about 2/3 of which are in the specialty pharma biotech space, and 1/3 of which are medical device. We represent medical device companies from inception all the way through going public in various areas, corporate, litigation, and patents, which is what we're going to talk about today. John and I have worked together for, over 7 years now. I've been with Cooley for about 12 years. We've been sort of impressed by the outpouring of the need for information due to the new patent laws. We're going to talk a little about that. We're going to weave that in. You might know that the American Invents Act is one of the most radical changes to the U.S. patent system in over 50 years. And really, it's not that big a deal. We'll teach you how to sort of deal with some of those issues and also how to respond, how you can use it to your advantage in dealing with some of your competitors.
Great. So for today, we have a roadmap for today. Great. So first, although I see tons of plaques on the wall, so patents are definitely not a news space. We're going to first go a step back, take a few minutes to talk a little bit about what is a patent, the fundamentals of patent law. From there, we're going to roll right into a discussion of freedom to operate analysis, something very critical. Oftentimes we find when we deal with startups, rightfully so, they're very excited about their innovation and they're ready to rush out and get a patent, which is great. Oftentimes, forgetting that you have to keep your eye on patents held by other parties as well. And so that's what we're going to discuss, talk a little bit about freedom to operate, what it is, and what the process entails. And then, you get your freedom to operate results. Now what? With some strategies for looking at those risks, trying to mitigate them. And again, there might be some areas where you can use your knowledge of the patent landscape of your competitor's patents to advance your position. At the back end, we probably won't rush through all this, but we have some search tips. And so if the presentation is available, at the end there are links for search tips for patent websites and other tips that you all might find helpful based on what you've learned there. So real quick, patent law primer. So what is intellectual property? We all know about our property, our cars, and our houses, and so forth. Intellectual property is really in many ways no different. You can still own it. You can transfer it. So it has a lot of the same characteristics as property. It just doesn't have physical existence. It's your ideas. It's often divided into 4 main categories: patent, trademark, copyright, and trade secrets. And today we're really going to be focusing in on patents. But the other aspects are not to be ignored, and often are a big part of startups and in the medical device industry. So what is a patent? Simply, it's a government-granted right in your invention. So if you come up with something that's novel, non-obvious, and is eligible for patentability, you can obtain a patent. What that will allow you to do is prevent someone else from making, using, selling, even offering to sell the patent product or perform a method covered by the patent. They're territorial. If you want to stop somebody from making or using something in the U.S., well, the patent term, generally 20 years from the filing date. And so, that's kind of the deal the government gives you. We'll give you this right to exclude people, and in turn, you're going to tell us by full disclosure what the invention is, and you're going to turn it over to the public in 20 years. Importantly, a patent is different from a trade secret in that a competitor can't stumble upon the same invention or, worse yet, reverse engineer it and claim, I didn't know about your patent, so I'm not infringing. If they are copying the claims, if they're meeting every limitation of the claim, they're infringing, whether they reverse engineer it or stumble upon it or what. Importantly, so that's what a patent is. I think critical to our discussion today is what a patent is not. So a patent is not a right to practice your invention. An invention can be patentable, but yet can still step in the minefield of another's patent. And as a quick example, say somebody invents a great new formulation for a drug, and the formulation is tailored and has the proper excipients and so forth so that it will fit in a new and unique container closure, perhaps with a stopper having a particular chemical composition. The inventor can rush out, get his patent on that drug composition, and then he wants to sell it prepackaged in the drug container. Well, if another party has a patent on that particular drug container, then even though the first party has the patent on the drug formulation, the second party can still knock on the door and say, hey, I'm glad you want to sell this. It's in my patent container. We need to talk. So the high point here is that patentability, whether you can obtain a patent, and freedom to operate, whether you're going to infringe another's patent, are two different analyses and need to be taken separately. So, real quick, a patent. The front page is where all the neat stuff is. Looks really cool. Got the identifying information, the patent number, list of inventors, who owns the patent. And notably, we'll say that that's the ASME as of the date the patent was issued. If they have since sold the patent, there's ways to check on who the current owner is and find the full chain of title. We have that at the end. Filing date and priority date. Again, terms was from the earliest non-provisional priority. What's not shown on the front page is the claims, and that's where the heart of the matter is for freedom to operate and really for anything else. So the claims are the part, they're at the back end, and that's what's going to define the patentee's rights. It's somewhat like your fence around the property. Everything inside the claim is your property. To infringe, an infringing product would have to do each and every limit or each and every element that's set forth in the claim. The format of the claims, they look like huge run-on sentences. Eric and I call them, and Robbie as well would call it job security, right? Because nobody can understand them. It's patent law forces us to do that. So once we can understand them and write them, then we have a pretty good gig. There are independent and dependent claims. And again, to infringe a patent, all you need is one claim of the patent. And that would, if you infringe one claim, then you're an infringer. Also like to note that claims are typically amended during the prosecution of the patent. So here's a sample claim. We won't go into great detail here, but with regards to whether one is an infringer, they would have to have each and every element of these claims. So this would be an injector device. They'd have to have a housing, cartridge container, and a cartridge that meets all of that. There's a limitation there. An actuation assembly, a needle cover, a first locking assembly, and a second locking assembly. So if you're making a product, and you're like, I'm putting a check mark by each of these, and it does exactly what it says, that would be a potential infringement problem. One last thing before we leave our patent primer is that, again, patent claims are amended during prosecution. And not only that, before a patent is issued, the patent owner, the applicant, has a chance to file continuing applications, continuations or divisionals, or what have you. And what that allows is the patent owner to essentially hold their place in line with their priority date, but yet continue to spin out new claims. So if you have a patent like many of the great patents on the wall here, say for a catheter device, you might have the first patent around the device itself, maybe the flexibility and what have you, how it can be traversed into the body. Before that patent issues, you can file a continuation and say, great, I've got that set. Let me look at it from the standpoint of methods. Can I get method claims for that? And that can go on really until the life for 20 years. And the advantage of this is, one, it can keep you can help keep pace with your product development. So often we'll have clients that will have a concept in development, we'll file the patent for them, put full disclosure in, and we claim it. But then in 2 years before the patent issues, well, we changed this around. And we said, well, what was it? Well, it wasn't really any big deal. It just makes the thing work. Right? You got to tell us. And then maybe we had not originally claimed that feature because now it's come to our attention that that's a hallmark of the design. We'll go out and file a continuation to get additional claims on that. Another thing that could afford is the opportunity to scan the landscape and see what your competitors are doing. If they're doing something similar, you might say, you know what, I think we disclosed that in our patent application. Let's file a con and we'll get some claims around that for a good bargaining chip. And so that's an area that we'll touch on today. And the key thing to watch out for is, are your competitors filing continuing applications? Because while you may be clear to operate over their existing patents, if they have really good disclosure, but they just haven't claimed it in a manner that you would infringe, you need to be careful because they might be out there filing continuation applications. Okay, so we'll dive right into the freedom to operate. So, freedom to operate is essentially the analysis to determine whether you are free to operate without risk or with limited risk of infringing another party's patent. Often, the risk is measured in various gradations. There's always some risk that somebody's going to come out of the woodwork with some patent. Oftentimes, it might be somewhat frivolous, as much as a shakedown as anything. But you do need to take the analysis to find out, are there truly problematic patents that could stop you in your tracks? So when do you undertake this analysis? Well, there's a lot of advantages. A lot of times it can be done. We recommend that you would undertake at least an initial analysis early in the product life cycle. So before you get tooling set, before you start an approval process and so forth, it's a good idea to take a look at the patent landscape, do a freedom to operate. Of course, it's also a good idea to update that search as your product develops. We have many clients, again, whose initial products change greatly as they learn from design for manufacturing, regulatory processes, and so forth. And so as they add new features or change features, what may once have been clear may now be a problem, or perhaps maybe the other way around. Another opportunity to conduct a freedom to operate would be as preparation for diligence. So you're getting ready to seek funding. If you've shown your concept, you're going to seek funding. First thing a lot of investors or potential partners are going to want to know is, do you have something that's going to block us from commercialization of this product? And if the answer is, well, I don't know, we haven't checked, doesn't usually bode well for a funding play or a partnership. So it's better to uncover the problems before they ask you. And it's also a good idea to uncover the issues early enough so that the design team, like the design team here, has an opportunity to do some mitigation activity. So what do you want to focus on with the freedom to operate? These medical devices that are developed here by you all are very complex with many different systems. What do you focus on? Well, you want to focus on your primary product. You could drive yourself crazy and spend a lot of money on lawyers, which nobody wants to do, if you clear every single thing. So you want to focus on what's your primary product, and within that, focus on what the distinguishing features of the product are. What are the features that are central to the functionality? What are the features that have changed from earlier versions? How are you different from what the industry is doing? If you're taking it in a kind of a radical new direction, that would be a good area to clear because you want to make sure that someone out studying, in grad school in Ames, Iowa, for example, or something, hasn't come up with something and obtained a patent on it that you just weren't aware of. What about off-the-shelf components? Again, quite often one might assume those are clear, and quite often they are, but that's not a good assumption to always make. If you're taking an off-the-shelf component and using it in a manner that's patented, then you might have a problem there. So just because it's something off the shelf doesn't mean that it's necessarily clear. So to talk a little bit about the process, to walk through the freedom to operate process, first you want to determine the project scope. Again, whittle down what features of my device do I want to clear. Again, I'll drive myself crazy and run out of money in a hurry if I want to clear every aspect, every material, every grommet, and every seal. So what you want to do is it an optical detection device. Well, maybe the way you're using the optics is something you think is new and it's very central to your device. So let's clear that. Many times for clients, we'll clear 2 or 3 primary aspects of a product initially, get a good feel for it, and then again, tack on to that as funding allows and the design evolves. It's important to know the geographic scope again, patents are territorial. So if you want to operate in the U.S., do a U.S. freedom to operate. If you're launching first in Europe, maybe you consider doing European first. And quite often what we'll wind up doing is most of med device companies, if they're going to file, they're certainly going to file in the U.S. So we'll do something in the U.S., but then branch out from there and hit Europe or other markets as necessary, depending on the client's business strategy. And, of course, budget time constraints. Search strategy, areas, where do you want to look? And, again, at the end of the presentation today, we have a whole list of sites and so forth. But for search strategy, you want to take a look at potential competitors. Who do you know that's out there that's going to be competing with you? Look for patents that they own. Potential partners, potential acquirers, for example. You might want to see what the landscape looks like from there. And also suppliers. We've had numerous cases where clients will work with a supplier, somebody they're buying a major portion of their component from. It's a good idea to know what patents they own in the event that something goes south with that relationship. Of course, you want to look for specific attention to companies in the field known to be litigious, and in the med device industry, there's no shortage of those. As well as sometimes you do an inventor search. If there's a prolific inventor, may have moved from company to company, that's a good idea to do a search by that person as well. And that's just kind of a beginning. There's other areas where things to consider for your search strategy. So then there's the analysis. And this is where we typically come in. Again, it's the whole job security thing. Review the claim to assess potential risk. And again, that's based on the claim. Quite often we'll see a patent. Somebody might bring it to our attention and say, this looks like a huge problem. It looks like it discloses kind of what we want to do. And we look at the claim, and if the claims, if you look at that checklist, are 2 pages long and have all kinds of elements that we're not doing, although the patent itself might be a roadblock to us obtaining the patent, maybe we're clear over it. So it all boils down to the claim. And again, that's an area where the flip side can also be true. Someone can look at a claim and say, well, that doesn't look, I don't think we're doing that. But of course, nothing's ever simple in the law. There's all kinds of gray areas, things such as the doctrine of equivalence. So even though it wasn't literally mentioned, well, what you're doing is equivalent, and so, yeah, you're an infringer. So the point there is, at that point, good idea to always have an attorney review the claims to determine the potential risk. Once risks are determined and you find out, hey, this particular competitor appears to be a big problem, maybe you go back and do a little additional searching. Let's scrub it hard, see what else they might have, see if they've been filing continuations and so forth. And then maintain a table of reasons of all the patents you've uncovered. Why don't we infringe it? This can be very helpful when the product changes, for example. So you know, look, this highlighted area was what got us out of the suit before. So engineers, don't go in and change it to do that, because if you do, we might be stepping right back into it. At times, the analysis will involve a review of the file history. That's the back and forth between the patent owner and the patent office, what they argued in getting their patent. And also, again, an analysis of pending claims. And again, they might be spinning out continuation, and if they see that you're coming to market, they might try and get claims that read smack dab on what you're doing. Okay, we have our results. Now what? So we'll start with a couple of options. The first one being licensing. A couple things to consider, and then we have a few case studies here, is first of all, should I license the patent? Say there's a problematic patent. A lot of that's going to depend on the nature of the patent owner. Is the patent owner a direct competitor? They may be less likely to license if they're putting out a competing product. Are they practicing the invention? Do they own the patent, but they work in a completely peripheral field, someplace that's ancillary to what you're doing? If so, maybe they're more amenable to license. Another thing to consider is, do you have any leverage against them? So on the flip side, while we're looking out for what they might have over us, have you applied for patents or have other leverage that might be able to use where you can meet at the table, each with your bag of bargaining chips, work out something that's more favorable to you? In considering licensing, I mean, we can be here all day talking about different terms of licensing. Is it exclusive license? Do you want to have the right to issue sub-licenses? Is it just going to be limited within your field of use? A lot of things to consider, but kind of the initial step is figuring out, is this even an option? Is this person that owns the patent going to work with us and give us a license in a manner that's not going to bankrupt us or throw us off track? So this one, I'm going to turn it over to Erik. This is his favorite story. He was deeply involved in this, and it's related to a company that we work with. And I'll let him take you through the case study on that one.
Yeah, this is my favorite story because it has a happy ending, and who doesn't like a story with a happy ending? So we represent a company, and they make a drug delivery device. They started developing their product in about 2004, and really got what they thought was the final product in 2009 or 2006. They had the design. We got involved. We really need to do a freedom to operate search. It's early in the product life cycle, but this is an incredibly litigious industry, very crowded space. We should do a search. After much wailing and gnashing of teeth, they agreed to do it. Once we found a very interesting reference, what we would have considered a significant obstacle to commercialization, we approached the company. It was actually an individual inventor that had his own company. He had never commercialized his device, had no plans to commercialize his device, but he had a really, really good patent that we couldn't invalidate. We tried to find references that would undermine the patent and couldn't. So we decided at that point, hey, you're a small company, approach the guy, maybe he'll license it. So for a very, very good price, because they were a very small company without anything close to market, he agreed to partner with them in some ways, but essentially license the patent. So flash forward, continuing product development in 2008, then we got into a very big diligence project in 2009 when a very large international corporation decided they were going to partner with this company. They sat down with them, and I remember very distinctly sitting in the meeting, and they said, okay, we've done our diligence. We found a patent that we think is a problem. It was very dramatic. They slid it across the table. I picked it up, and I said, we've licensed this patent, and I slid it back. And they just kind of couldn't believe it. They literally couldn't believe it. So we, again, ended up licensing the portfolio to that company in 2009 for what amounts to more than a couple $100 million. But that very, very small sum of money that we paid early on, because we found the patent when the company was literally nothing. I mean, they were a couple of guys trying to build a product. It worked out incredibly well. The company has FDA approval, and they're going to launch next year. So that wouldn't have happened, I would guess, if we hadn't found that problem. Because if they were trying to do a deal with that other company, guess what? That big company would have gone and bought that other patent. They would have thrown us to the curb, and they would have developed a product about us. So it made a very big difference. And then just real quick before John comes back up, you reminded me of a funny story. So John said people don't like to pay lawyers to clear everything. We had a client, it was one of our favorite clients, because they apparently did like to pay lawyers. They cleared every product and every feature of every product they had. It was a children's products company that decided, even if it was a toy that you squeezed and it lit up, they wanted to clear it. It was just like everything else they had ever done. Every time they came out with a new one, they wanted to clear it, except for the one time when they forgot. Had a new product coming over, they called us and said, hey, we have this new product come over. We don't know if we ever told you to clear it. And so they gave us the information. No, you never told us. We did some searching, and of course found 3 patents that they were going to directly infringe, and they had to turn the boat around and send the products back, and it's a legal launch. But anyway, so some people like paying lawyers.
Okay, so option number 2, and in a room full of engineers, this is my personal favorite as well. Look, we got the claims out there that might cover it, so let's change what we're doing. Again, if you've got the freedom to operate done early enough in the life cycle, we have time for all of you smart folks to go out there and figure out how to get around it. And there's always a way around it. But then there's the issue that you have to determine is what's the nature of the problematic feature. Again, there's always a way around, but is it an easy way? Is it something that's really central to the product? If it's a peripheral item and something that can be easily redesigned, for example, a lot of times there's method claims that might be related more to software. Well, that is often a little easier because you do that before you have without tooling and molding and so forth. So you're going to want to figure out the nature of the feature. It can be a less expensive way to avoid the problematic patent than a license. But the one watch-out, or not the one, but one of the watch-outs is that patent family still pending? Again, you might redesign it and say, well, maybe they claimed something that was an optical system with LEDs for the light source. And you decide you're going to design around and use a different light source. If they have it pending, their patent application included all the other light sources, in fact, the one you use in your design around, they could go file claims with the con and say, you know what, they moved here. It's like a game of checkers. Well, I'm going to move there with them. So you need to be cognizant of who holds the patent and are there pending continuations. Of course, the cost of a redesign versus the cost of a license. In some cases, you can get a license really cheaply, and in fact, if you get a license that allows you to sub-license, you've strengthened your own portfolio. So a redesign isn't always the answer, but it sure is fun. And then finally, is there time to redesign? And what I've just heard from Mary is that you guys can do it so quickly, there's always time. Right? So, got another war story here, and this is one. It's a design around it. This was a client of ours that we worked with. They were developing a diagnostic system, very complex system with many features. They began working on this in the 2006 time frame, really cranking away on a very complex system. We got involved in the end of 2009. Our FTO was a pretty major undertaking for that, where we looked at 3 or 4 primary systems of this system, some of the components, and of course, as luck would have it, let me back up, because that's the fun part. As luck would have it, bad luck that is, we uncovered a couple of problematic patents. And in particular, there was one related to a certain aspect of the device. We provided that back to the client. The patent owner was one that was not going to be amenable to a license. So the answer there was we need to figure something else out. So they drew it to the engineering team, and within a couple of short months, they had a new design. We took a look at that, and we worked with them kind of shoulder to shoulder to say, okay, when you're designing, here's the areas that you can paint. Don't paint here, don't paint there. Go to it in this space because you're going to be clear. And that's what they did, and they came up with something. And not only did they come up with something that got around the patent, they came up with something that we believe itself was patentable. So a month later, we filed a provisional application that included, among other things, their redesign effort. So fast forward again now to 3 years, 2.5, 3 years later. Again, this company then found themselves in a diligence with a potential partner, and of course, that reference came up. And it wasn't quite as dramatic as the picture Erik painted, but nonetheless, the references came up, and we were able to convince them that our design around, in fact, was clear of the product, of the patent, and so ultimately the deal was completed earlier this year. And it's kind of a funny story about that is we had to convince the business people about the risk. So we had lawyers trying to interpret what engineers were saying, engineers trying to interpret what the lawyers were saying, and the business people just stamping their feet and screaming. So, but again, it was a happy ending because having uncovered it early, getting it fixed, when the rubber hits the road, the issue is taken care of. And so I think the lesson from this is both of these stories is if there's something out there, when the stakes get high enough, it will be found. It's better that you find it up front. Okay, option number 3, invalidation. Erik mentioned, hey, we tried to invalidate the patent, we couldn't do it. So there's a couple ways, actually many ways you can invalidate a patent. We're going to run through these pretty quickly. These aren't as applicable to startups, especially the first with litigation. Very expensive, time-consuming. I'm personally afraid of court. Other attorneys aren't, but Cooley has a great stable of attorneys who aren't, including Erik. But again, that's an option where you can go to court, put forth your evidence in court that says the patent should have never been granted. There are also procedures at the patent office, the USPTO, for basically petitioning the patent office to say, look, you guys made a mistake. This patent shouldn't have been granted because, look, I have this paper from 10 years ago that shows exactly what they patented. There are several mechanisms for doing this. There's ex parte re-examination, inter partes review, post-grant review, and then we're going to talk a little bit about pre-grant submission of prior art next. The inter partes review and post-grant review are part of the new American Invent Act that Erik mentioned. One thing I'll say about these, and again, directed toward an audience of startups, ex parte re-examination before September 16th of this year cost about $2,500 in patent office fees to file. Now, $1,700. And that's not counting the time to draft and prepare your projection. Now, $17,000. Yeah, thank you. Extra zero at the end. Inter partes review is even higher than that. So again, these are options where, for a startup, depending on the stage you're in, may not be the right mechanism, but want to bring it to your attention. And of course, that would be part of your consideration. submission, though, is something that might be applicable more on the startup front. And that pre-grant submission, again, that's a new procedure resulting from the American Defense Act. And what this allows you to do is if the patent application is still pending, so before it's been granted, if you're monitoring what your competitors are doing, and you can see, look, they're heading down the road of getting some claims, or they have a patent where they might get some claims that cover what they're doing, well, you can do a pre-grant submission. So what that allows you to do is submit to the patent office the prior art, the references that you think would invalidate those claims, and along with your reasons of why you think that the patent should not be granted over these references. And then the examiner will act on that, hopefully reject the patent and force them to change their claims in a manner that's no longer going to be harmful for you. So again, there's certain rules you have to follow within the time period. You have to include the statement of relevance. And that's, again, where you have to detail out why you think what they're trying to claim should not be allowed. And, of course, importantly, it can be submitted anonymously. Cost. If you're only submitting 3 or fewer references, no fee. If you're submitting groups of 10 references, $180. And, of course, there is the cost to draft a statement. And, again, you wouldn't want to give that short shrift, and we'll talk about that here in the next slide. So advantages. I mean, it's the best case scenario would be the patent applicant just abandons this gosh, this art is right on top of what I'm trying to do. It's a dumb idea. Or they yell at their patent attorneys and abandon it. More likely what's going to happen, though, is they're going to find something that they can claim that would be patentable, but hopefully it narrows it out so when you think of it as defense, you're going to push their fence in to where it's in an area that's not going to bother you with your product. So what are the risks of this? Sounds great and cheap. Why not just start lobbing it onto the patent office? Well, although it could be submitted anonymously, it does alert the applicant that there's some interest out there in the field. They may be able to figure out who's doing it, who's the players, and give them a heightened sense for what's going on. Worst case is examiners are human. Sometimes they don't see things the way we do. They may say, look at the art, say, I don't see what you're seeing, and grant the patent anyway. And now you're actually in a worse shape because you've kind of used your good salvo of references. The patent office has already said, no, it's patentable over those references, so the patent that comes out is actually stronger. And that's where you don't want to give short shrift to the concise statement of why it's relevant. It's because if the patent is granted over that art, you now have a bigger problem. And, of course, it's relatively untested. Last but not least, and trying to allow some time for questions, is kind of option number 4, trying to obtain some bargaining chips. And this is where maybe a landscape search and understanding the competitive landscape can help you out. So if you have a good knowledge of the patent landscape and know the industry direction, where everybody's headed, maybe you can strengthen your own patent portfolio in a manner that's going to be a block for others down the road. So, for example, if you see that drug delivery is headed in a certain direction and you have patent applications that have an early priority date where you threw in some alternate embodiments in that area, maybe you file some continuation that would claim this area where you now see the industry heading. It might even be worth doing if it's an area where you yourself might not be going, but if you know one of your industry players is actively working in a particular market, getting some claims to cover might not be a bad idea, if nothing else, to increase your bargaining chips for if they come after you. So again, doing some searching, you can uncover a lot about who's doing what are they pursuing, and so forth. So again, filing continuations is a very good and common strategy to strengthen your own portfolio. Another thing that you can do is identify strategic patents owned by third parties. And, for example, if you find the patent is owned by a third party who really has no interest in commercializing, maybe, again, they're a solo inventor with a small company, you might approach them at an early stage if you're not on their radar. Maybe they're amenable to licensing at a reasonable level where you might get a very nice patent that could block where the competition is heading. So again, if you can find out from what the competition is pursuing in their patent where things are headed, go back behind it, find either your own disclosure or other patents with better dates, you might have a good way there to block what you're doing. So search tips, again, we'll go through this super fast, but I do want to alert you that the search tips will be available for you all in the presentation. Again, kind of bottom line is it's good to search, it's good to activities, who's suing who in the field. That gives you an idea about who's litigious, who might be amenable to licensing, and so forth. So whenever we uncover a problematic patent, that's areas where we look, see who they are. One way you can do that is to search the U.S. Patent Office website. It's got the link up there. You can do keyword searching, searching by affinity, search just within the claim, all sorts of different things. I personally like the free patents online. It actually is free. They do require that you get a login, but I've never got anything bad or spam from that I know of. Google Patents is also pretty good. To a better page, we talked about searching for your specific competitors. On the face of the patent that I put up initially, it had a name. And I said that might not be who currently owns it because that company has been sold. The USPTO has a recordation database where it's 90% of the folks, as it should, properly record who the owner is. So you can see the whole chain of title. Whose hands has the patent passed through? That's up here as well. So when you're doing a keyword search by affinity on free patents online or others, you might not find everybody. Search sites for international. Other things to think about is have you got all the names of the companies, subsidiaries, and so forth, who's bought whom, you want to kind of dig into that and find out all that. Finally, unpublished applications, you can find out about their existence, although not their content. In some cases, like if it's a continuation on the PTO repair webpage, that will also tell you if they've been filing continuation. And we'll stop there, and certainly appreciate your kind attention. Welcome any questions you all might have. Those are kind of quick. It doesn't allow it.
Yes, there are some questions online, but we can take some off from the room at first. Erik. The question was, what's the backlog on patent processing issues?
Yeah, it still depends really on the technology sector. In the medical device space, we're looking at still about 2 to 3 years. One of the features of the American Invents Act was that you can now prioritize examination of your patent application. So when you file, a small company can pay $2,400, a large entity can pay twice that, and the patent office guarantees you that you'll have an answer within 12 months. And that answer might not be a good answer, but it's an answer nonetheless. Typically, we're seeing the first action out of those prioritized examination requests coming in about 6 months. We advise clients, really depending on their stage of development, maybe you don't want that yet. Maybe you don't want that answer. If you're out looking for funding and the potential investor knows that you have this prioritized examination, they're going to wait until they get that first look from the patent office. If you're on that 2 to 3 year track, maybe it muddies the waters enough that they don't want to wait 2 to 3 years to go ahead and do the small investment now, get things going. You can decide to do prioritized examination later. One of the really nice things about prioritized examination is that the application won't publish until the patent office is done. So the patent office goes through their process, you have an answer in 12 months, and it won't see the light of day if it's not a good answer. So that's not a bad thing. But as far as backlog goes, that's really the only way to avoid the current backlog. Yeah. Yeah, it won't publish until 18 months, right? So 18 months after the original filing, it will publish. Unless if you went through prioritized examination, got a bad answer, and decided to just abandon it, you could abandon it to avoid it ever publishing.
And then on the
freedom to operate. That's something you all do. Yes,
I'll repeat that for the audience online. Freedom to operate, because it's a little bit soft. Freedom to operate, is that something that lawyers at Cooley?
Absolutely. So Cooley, one of the focuses of our practice, not only is obtaining patents and the patentability side, but the freedom to operate. We have a stable of searchers, external searchers, and we scrub to find the prior art. And then again, when it comes down to reviewing the claims, that's right up our alley to review claims and try and then work with clients, not only just to throw an answer over the wall. Yep, there's a problem. See you later. But to work with the client and say, okay, what's your business needs? What are the best options for mitigating this risk?
Well, in connection with either investments or partnerships or acquisitions, we do diligence on both sides. So we represent companies in connection with freedom to operate diligence, as well as investors for acquisition.
So any sense as to what impact there might be if your freedom to operate, you're clear versus, yeah, there's some infringement to the exit valuation since you've done some M&A stuff for both
Yeah, it's a huge impact. And, in the one deal that John was talking about, the diagnostics company, there were definite issues that came up along the way that the other side was not really thrilled with. We had our analysis and we had our position, but they were very close calls, and something that we put in a higher risk category than you're free to go. So it definitely impacts the valuation without any question. If you can give it all clear, that's great. Doesn't mean you are all clear. It means that after a diligence search and analysis, we think you're all clear. Like John mentioned, you can still face some shakedown suit, or where you think you're clear, your competitor might not. But a negative result in a freedom to operate analysis will definitely impact the exit strategy.
percentage devaluation? Any sense?
I think it
Round figures.
I think it depends on the risk. I mean, I think if you're up in the high risk category, way down. It's going to bring it down by half, and we've seen it really come down by significant value. Where we had a diligence we worked on, the company essentially got out just so the investors got their money back, and that was the end of it. It's really zero sum game.
And kind of further to that point, they're all shades of gray. And so if you have one kind of gray area, maybe not terrible, but it starts stacking up the grays, the other side's going to say, they're going to drive the value down. Get to a point where investors are just wanting to get their pile and get out.
So this is actually a patent agent at North Carolina State.
Oh, okay. Right. I think
I guess you would feel comment. You damage it. Okay, so I'll read the first question. If a patent has claims pending, and you go ahead with a product that infringes those claims, the damages accrue from issuance of the patent or from when you become aware of these claims.
Right. Damages don't start to accrue until the patent issues. So if your product is launched and then later the patent issues, damages don't accrue until the very beginning. The one sort of handicap to that, or caveat to that, is if you have a published application. So if the application was published and the patent owner or the applicant sent you a copy of the application, the published application, and said, I'm putting you on notice. If a claim in this application issues in substantially the same form as it is right now, you're going to be liable for some measure of what they call provisional damages. It's not the same level of damages you pay for an issued patent, but it's something in between. You rarely see that happen, as John alluded to. Claims are often amended during prosecution. But that, other than that caveat of provisional damages, in that very rare circumstance, that you're going to end up with, you're not paying until the patent issues.
And I think the second part of that question was, if pending claims looks to be a problem, you advise the client to move forward with that same design. And I think, again, that's going to be a judgment call on what we see some very broad claims that are filed, where our look at them as, oh my goodness, they'll never get anything close to that because we have all this art here that it's just wildly valid. In a case like that, the client, we might advise the client, say, look, we think it's a low likelihood that they're going to get claims issued for. But on the flip side, if it's a claim that appears to be headed for patentability, and you're going to step into it, then we would, I think, have a different take on that, and might advise the client to pursue the options. And again, if a license can be had for very cheap, sometimes that's always a nice option.
I think, and it's not in the question, but I'll get there anyway. The bigger problem, the bigger risk for a small company is injunction, right? So damages are a problem, and damages start to accrue, again, with the patent issues. But the bigger risk is that patent holder coming and shutting you down. So if you end up in a situation where you could have launched your product, or you're about to launch your product, the patent issues, if they seek a preliminary injunction, tell the court, okay, before we even decide this suit, we think there's enough of a likelihood that we're going to succeed on the merits here, that you should just prevent them from launching their product right now. That's an even bigger problem. closing down the issue.
And I guess there's a second part. Supposing you find a patent owned by an academic institution, and you know that academic institution tends not to litigate, would you ever recommend to your client not to take a license based on the non-likelihood of litigation?
Yeah, no, my answer there is absolutely not. I never recommend that to a client. If we found a patent that was a problem, even if we knew the university would litigate, that somebody might go and license that patent from the university and then litigate. So I would advise the client, go approach the university. If it's an unlicensed patent, universities like to license their patents. I would say approach the university. But never would we say, yeah, you won't get sued. I mean, that's a malpractice suit. We can come back when they do get sued. Yeah, and lawyers are way more risk averse than that.
The other thing is, in a situation like that, one thing we'll often do is make a blind inquiry as the attorneys on behalf of the client. So again, if the client's a little uneasy about, they don't want to maybe reveal who they are to the university, or work through an attorney or something, they'll make a blind inquiry to the university, feel them out. What are the terms? You might find out it's incredibly cheap compared to what you might have thought.
John, can you comment on the main aspects of AIA?
Okay, so right.
The question was just a little bit louder. It was
AIA,
okay.
new act of AI.
Right.
Now, it is changed now from the first to event to first to
Right.
Maybe John can address that.
Sure, absolutely. Thanks, Robbie. So I think with regard to startups and small and nimble outfits, first to invent, under the prior system, America was different than the rest of the world, and that it was a first to invent country. So if an entrepreneur came up with a new medical device, had great notebooks and proof of their invention date, just didn't have the money to file a patent application, although they were working diligently, and were able to then file in a year. But say that the big company came up with something similar independently, happened to be intervening and filed under the first to invent, the individual would have won and would be granted those patent rights under the American system. That's it's very American in nature, looking out for the individual. Part of the American Defense Act, though, is somewhat in keeping with harming the rest of the world. So the U.S. is now moving to a first to file system, meaning that even if you have those great early dates and you came up with it first, if you didn't file first, the party who files first will be the one who can get those rights. Now, they can't steal it from you. So it's all about independent invention. The other thing is it's kind of a first to file or publish. So if, as a small inventor, you publish something first, you will have a year grace period still within which to file, and that's going to cover you. But so the bottom line for small entrepreneurs and startups is that you're going to see a lot more filing of provisional applications. Hey, we've got this to kind of initial concept stage. We've got these great things to do with patentable. Well, go ahead and get a provisional on file, even if it's kind of a quick and dirty. And you can serially file provisionals and then roll them together in one non-provisional filing within a year. Whereas previously, I think folks might have been a little more likely to wait and to say, no, we're going to put that expense off and file it. The other thing to note is that the change takes place on March 16th of next year. So for a company that filed a provisional, say, today, technically they have until, what is today? So they'll have until October this time next year to convert their provisional. But again, we would recommend they consider strongly filing their non-provisional before March 16th of next year rather than waiting for October, so that the filing would fall under the first to invent system rather than the first to file, especially if they have earlier inventor notebooks that might even predate their provisional filing. Does that give you some insight or some more thoughts? Anything to add there?
Yeah.
Okay. Happy to talk about it more after the session, certainly.
One more thing. Value of freedom to operate opinion, okay, medical device field. Okay. What do you think about FTO opinion? Okay. In case there is infringement issue.
Right.
FTO opinions and infringement.
Okay. So an FTO opinion then would be somewhat of Bobby mentioned as an opinion would be if you could show the court that, oh, no, it wasn't willful. We had a well-reasoned opinion of counsel that said, we don't think you're infringing, maybe this, we had a well-reasoned opinion of counsel that this was an invalid patent. Even if it was later found to be valid, if you had a good reason for it as a formal opinion, that can mitigate against those triple damages. We have been finding lately, we don't do nearly as many opinions of late as earlier. And a lot of times, they're very costly. Opinions can be $20,000 plus undertaking because it has to be well reasoned. You have to analyze every claim and so forth. And so especially for startups, it's usually something that is not really going to be the recipe there for that.
Yeah, I mean, it used to be that if you didn't have an opinion of counsel, it was per se willfulness, where the court said, you knew about the patent, you proceeded in willful disregard, it's willful and troubling damages. Now, if you don't need an opinion, you don't need a written opinion. So since that case came out, we're less inclined to write opinions where you can verbally tell your client, you're good to go, here are the reasons why, put a quick memo in the file, and you're still okay. In a situation where it's a little bit closer to a call, you're really parsing the language very finely, you're really not sure which way it's going to go at the end of the day, then you write opinions. But really only in the closest of situations that we're writing opinions now.
I have one more question to tack at the end. So has your company or any other groups been put in a situation where you have two parties, you didn't know that they were against each other, and then they're both your clients? How do you
We try to avoid that. We have a very sophisticated and carefully run conflict process.
Okay.
So we run conflicts based on not only the company name, but subject matter as well, or any patent work that we do. When you're just doing the corporate work, it's very different because you're not really getting into the technical details, and you can just divide the teams. But on the patent side, we're very careful to make sure we're not representing two companies that could possibly converge. We represent multiple companies in the same space, but just that are on opposite ends of the same space. So in the diagnostics field, we have a bunch of clients, but they're all very much in their own vertical within that space.
And I guess the flip side of that for our clients would be the question of how to choose someone best to represent based on is there
Usually it's just who came first.
Well, who came first? Oh, to choose what the better the law firm.
the firm and
Choosing a law firm, dealing with lawyers can be interesting. So it's kind of like a doctor-patient relationship. The way we like to approach it is you got to find an attorney that you trust, somebody that you feel comfortable with, that understands your technology, and that's also understanding of their business. Where are you trying to take things, so that they can develop a strategy that fits where you're going, rather than just crank out patent applications. We all love to write them, and we have folks back in Reston that are great at it. But if we're just writing patent applications without understanding the end goal with the client, then we're missing the mark. And so, as you're searching for attorneys, I would recommend that you find somebody you're comfortable with, that knows your technology, that knows your space, and that will listen and be responsive.
Right. Yeah, and as someone that's going to partner with you, someone that's going to be that cares much about the business and be a counselor and a strategist as well. I think that's an important part. Because you don't want just a voice on the other end of the phone that really doesn't care about the company. You want someone that's going to be involved.
So interview them, really. Even if you like one, of course we'd love to be Cooley always, but if you like us, go interview others. That's a good way to find out who you mesh with that.
yeah. And I guess I don't know if there's a difference between startups versus larger firms like Cooley. Is that separated in Cooley, where they have each of you specialize in different groups, or it's pretty much independent?
It's pretty independent. John and I both represent very early stage companies as well as much later stage companies, public companies.
Our goal, and I guess you look for this in any other attorney, would be the goal, regardless of whether you're the big Fortune 500 or the small startup, that you get the same treatment, same value for your dollar.
Can you give us a couple of examples of some of the most historical infringement cases that have been published and awarded?
Infringement that we literature that we've worked on, or just some of the
most historic infringement, famous infringement cases?
Yeah, I mean, in the medical device space, I mean, it's got to be the stent wars, right? So there was significant litigation over drug-eluting stents for years. You know, Johnson, in fact, got out of the business of drug-eluting stents because they were sick and tired of the litigation. I mean, Boston Scientific was one of our clients for a long time, no longer is. But you know, and not because we lost the case, but because they were taking up a very large conflict footprint. They paid and received hundreds of millions of dollars, but the drug-eluting stents in the medical device space. And then most recently, you know, the Apple-Samsung case where Apple just got $1.2 billion from Samsung, and that was all based on design patents. Those were patents that only protected the ornamental appearance of the iPhone and the Samsung product. But yeah, so that was probably the most recent significant one.
But I mean, what happens in this kind of case?
They pay damages. They
pay damages, but right from the beginning, they must have done all the studies, right? Or got some bad advice. You know, so I think on the design patent case that Erik just mentioned, I think they did.
Samsung didn't care. They didn't care.
Yeah.
I mean, I think you get sometimes it's a matter of the way the claim gets interpreted by the judge. You know, a judge is going to make a decision as to what each claim term means, and sometimes you win, sometimes you lose. And then after the judge makes his decision, sometimes it's right, sometimes it's wrong, and they throw it to a jury. And a jury, you know, these are people who couldn't get a jury duty, right? They're sitting there listening to these hyper-technical arguments about things that they may never care to understand, or maybe they do, maybe they don't, but then they're going to make a decision. Who knows what plays into that, right? So it's a very imperfect system, but it's going down. So that's why very few patent cases actually go to verdict.
6% or less, right?
Wow. All right. I think we're near the end of our time, but let's give another round of applause for our